crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you for joining us tonight. Got a really informative panel, an interesting topic tonight that we think you're really going to enjoy hearing about and learning about. And we would love to get you involved in the program. Always better when you are involved. There are ways you'll see at the bottom of your screen where you can get in touch with us. Call, text, email, whatever works best for you. Also, don't forget, Hollis Wright makes available each and every time we are here for the attorneys who are standing by live just to speak with you. That's a free, off-air, and confidential conversation. Just get in touch with them. 844-LAW-TALK. 844-LAW-TALK is the number to know. Leading our conversation, the managing partner of Hollis Wright, Josh Wright. How are you, sir?
Doing great. How are you doing?
I'm doing good.
Everything well?
It's all good.
So, it's fabulous.
Good.
If you had to guess, what percentage of litigation-based cases do you think, David, end up through resolution as opposed to an actual trial?
So I would say probably 20-30% go to trial.
Okay. You'd be incorrect, but close.
Often.
Roughly 85 to 90% of cases are resolved through some level of alternative dispute resolution. Those statistics change yearly. After we had COVID in the past, there are a lot of cases that are probably they're in the trial docket right now that are going to get resolved, but many that will probably try because insurance companies have kind of hit a reset button a little bit on how are we going to be managing this litigation. So there are some more cases that probably will try in the future from where they have been in the past. So that statistic changes a little bit from really decade to decade, but most of litigation-based cases resolve through an alternative dispute resolution process.
Okay.
We are lucky tonight because we have brought Ken Simon on, a dear older friend of mine that I've been practicing with for many years. We've been against each other. He's mediated cases for me, and now he mediates and resolves cases for our law firm all the time. And Ken is one of the city's best mediators. And so we're just super happy to have you on. It's always good to see you, dear friend.
Josh,
it really is.
You're too kind, and I appreciate the invitation to be here with you and David. Thank you.
So, a lot of these cases resolve through some level of alternative dispute resolution. First of all, how did you get involved in this? I know your history, but tell everyone a little bit about your history of how you got yourself involved in this area of the practice of law, because not everybody mediates cases and uses arbitration processes to resolve cases. How'd you get into this area?
Well, it started when I was a circuit judge here. I spent a number of years as a trial judge here in Birmingham and Jefferson County, and somehow or other we were just struggling for answers to how to manage the large dockets that we had back at that time. This was in the early to mid 1990s, and about that time a discussion started about alternative dispute resolution, some other way other than just going to trial. And that way that we started to focus on was through the mediation process, also the arbitration process, but primarily through mediations. Nobody knew what a mediation was at that time, and we got it confused with a lot of other things. But what we realized was that, hey, look, these cases really don't have to settle on courthouse steps. And if we instead intentionally start getting the parties together to work through their differences, maybe we could find a way to unclog these documents and move more cases through the system, giving people their day in court much earlier than what was required. So mediation really became a reality through lawyers who were leading that charge and judges who were doing the same. We started to promote mediation, and when I left the bench, I decided that, well, I think I know something about how cases can be settled, and that's how I got my mediation practice started.
It is such an integral part of our practice. We are mediating cases every single week. And, the thing is, David, that mediation is a great alternative to trial, it gives some level of closure to a client, and it gives certainty to a resolution. And so, in general terms, what mediation is it can happen all the way from the start of litigation until the courthouse steps, and it allows people to have almost, as Ken said, a day in court where the lawyers come together and they have an opportunity to talk through the issues, the theories, the defenses, and potentially resolve cases. So it's a great mechanism to give a client some control of how to resolve their case. Now, sometimes it doesn't work, and sometimes we end up at trial, and that's just part of the process. But the times have changed, as Ken was talking about in the 90s, where we tried a lot more cases. It's just the number of trials has reduced significantly over the years. But this process that Ken really has kind of started and championed in this area has been super successful for litigation-based cases.
So how do you decide if you go the route of Ken and mediation versus the other alternatives? How does that decision take place?
Well, the experienced lawyers know that there's not a lot of point in sort of delaying using the mediation process. It's such a good tool, they know, so they don't really play games, and they talk to each other, believe it or not, and they consult with their clients, and they decide that, hey, let's give mediation a shot. Sometimes, however, the experienced lawyers are not the ones who are managing the cases. And judges often have to step in, and they will order mediation to occur. Now, I should point out that it's a voluntary process. That is, a mediator like me, we don't have the power to order a particular settlement. All we can do is try to use persuasion, reason, and just the opportunity to collaborate on a potential outcome. That's what gives us the ability to get cases solved. But we get cases resolved at the right time by using mediation.
Yeah, talk a little bit about, and this always confuses my clients, I know, and it has changed the way that I get them prepared for mediation. Mediation is a confidential process too.
You got it.
And so explain a little bit about why that matters.
Well, it matters because it encourages the participants in the mediation to be candid, both with each other and with the mediator. That is, if you're in any negotiation, and that's what mediation is, it's a negotiation between the parties, but in any negotiation, you don't really want to show weaknesses, you don't want your claims or defenses that are not so strong, you don't want evidence that's not so great to really be out there in the open. And you don't really want anyone to think that you're afraid to try a case. Yeah. So the thing about mediation and its confidentiality aspects is that it's like having an off-the-record type session. Yeah. So proposals that are exchanged, information that's exchanged for the purposes of the mediation, all of these things it's sort of off the record, and it can't come back to haunt you. That is like before a judge or a jury if the case doesn't settle at mediation. So the rule of confidentiality encourages both sides to be open, transparent, and candid with each other and with the mediator, and this really does help get the cases resolved.
I know we're getting ready to go to break. Let me just mention two very quick points on that. One is if you mediate, the jury never finds out. So you can be at one number, and then you can go in front of a jury and you can ask for a totally different number. Number two, your judge only knows whether mediation was successful or not. So your judge doesn't understand and get the knowledge of what happened confidentially at the mediation on purpose, so that the judges are not influenced by what happened in those proceedings, and they can still try the case objectively like they're supposed to. So mediation serves a super, super important purpose. When we come back, I want to talk more and unwrap a little bit more about kind of Ken's practice and how he handles cases and his strategies for working with parties.
All right. Fantastic. We are stepping aside our first break of the evening. As we do so, a reminder, check out Hollis Wright on social media, Instagram, YouTube, Twitter, everywhere. Facebook, they're everywhere that you are. Check them out there. Really fantastic educational, informational resource there for you. Stay tuned. We are coming right back.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with The Attorneys.
Welcome back in to The Attorneys. A really interesting conversation about mediation. I hope you are enjoying it as much as we are. Before we get back to the conversation and to Josh and Ken, just a reminder, if you want to be a part of the conversation, we'd love to have you do so. And those attorneys from Hollis Wright are standing by. 844-LAW-TALK, 844-LAW-TALK. They're going to be available for the next couple of segments while we are on the air tonight.
Ken, let's talk just a little bit about kind of your process that you use. You know, most people that are watching don't understand the specifics and the nuances of mediation, but you know, ultimately you don't really have a dog in the fight as a mediator. Right. Mm-hmm. You're coming in objectively and you're trying to use your talents of persuasion to make sure that each side sees the potential pitfalls of litigation and of the finality of a mediation. And of what happens if they have to go to trial and what pitfalls they may face. What strategy in general terms do you use to try and encourage parties to evaluate and consider all those potential circumstances?
Well, I think you've sort of explained the situation that the parties and the lawyers find themselves in. That is, over the course of the litigation, they've probably become somewhat angry with each other. A little bit disturbed at being at the mediation, and we need a place where they can kind of calm down and look at the whole situation, not emotionally, but objectively. And that's what my role is. So I put on my hat where I'm calm and cool, and I try to use my experience from 40 years of law practice and litigation and being on the bench to try to bring perspective to the situation. So in the mediation, the parties are not all sitting around the same table throughout the mediation. We might do that at the beginning, but I try to separate them so that we can talk confidentially one-on-one. The mediation process really starts before we even get to the actual physical mediation, to that conference. It starts usually with both sides presenting me with information about their case. So I really do get a good flavor of what the case is about, and any negotiations that have occurred. So I'm prepared. So I know what it's about. So when we start the mediation, everyone does get a chance to have their say. And my process usually is I'll let everybody start the mediation by exchanging proposals, having an opportunity to vent. I don't really interfere that much, but inevitably we sort of bog down and we sort of hit an impasse. So at that point, I know it's appropriate for me to step in and exercise leadership.
Yeah.
And that's important for a mediator to exercise and show leadership, guiding the parties to a resolution. Now, during this whole process now, I've had a chance now to really understand the case a lot better and develop a sense of where a case potentially can settle in a way that would be fair to both sides. And the thing about a fair settlement, it's usually not what either side wants, right?
What do they say about the best resolution? Both parties are a little unhappy, but the case got resolved.
There you go. And so that's my goal, to try to find that common ground, that space where both sides could go and feel like, okay, well, this is a good resolution. It's not what I expected or wanted, but it's something that that I'm satisfied with, all things considered. So I try to use various techniques to get the parties to that particular place.
Can I ask, so he's talking about mediation from his viewpoint. You've worked with him. What makes Ken and what makes a good mediator?
Yeah, so a couple things I'm going to unpackage that Ken said that are super important. One is, have you ever heard the concept that people crave and will follow leadership at moments that they need it the most? Mm-hmm. That is what a mediator does, and that's what Ken does really, really well. It allows both parties to have a respective position, but use a leader who has a little gray hair, if you will, because he's been around both from the judge's perspective and as a litigator and now as a mediator. So he's got a lot of experience in that area. It allows us to follow a leader to a potential resolution, a pathway that I may not can propose as the lawyer because it makes my side look weak that I want to go down that path. Right. But Ken can do that as a former judge to kind of lead, guide, and direct us to that. So leadership is super important. Number two is emotions sometimes run high in litigation. I like to try and only get emotional at times when I absolutely have to, and that's generally when we're in front of a jury and sometimes in front of a judge when there's an impassioned argument, and I try and stay cool as best I can otherwise, but my clients don't always stay that way. This is a very emotional time for them, and I'm handling and managing the business side of their litigation. There'll be time for emotion when the time is right. Ken provides a very calming voice where when things and tensions get high, he can resolve that with good leadership and just with a calm voice to be able to get everyone just to reassess, step back, separate, and potentially find a pathway to resolution. Good. I know that was a long answer,
that's good, though.
But that's the best way I know how to explain. Using a former judge to do this as one of the people that really kind of started this in this area, it's super helpful to use a guy like Judge Simon.
A question we've got here about what if I want my day in court? Can I be forced to settle?
Yeah, great question.
Well, that is a great question, and the answer is no. You can't be forced. And there are times when I do run into that mindset, so to speak, where people are just intent on letting a jury decide the outcome. And that's fine. They're entitled to that. But at the same time, I feel that it's my obligation to provide the opportunity for the parties that want to settle to do so. Yeah. So my whole goal then is to put the mediation process, put the case in a position where the parties can make a decision, not leave things so divided and separated or emotional and tinged with bad feelings that we won't ever find a way or a pathway to settle it, but rather that gives each side a chance to get it worked out.
All right, I know we're going to break. When we come back, I want to talk about how technology has impacted, like Zoom and other things, has impacted the process that mediators use to resolve cases. We'll talk about that when we come back.
All right, we are stepping aside. Our final break of the evening. Stay tuned. The final segment of The Attorney is coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in full. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WVTN 13.
Welcome back into The Attorneys. Time is flying, almost through the show, less than 6 minutes remaining. So take advantage of that opportunity to speak with the attorneys. 844-LAW-TALK. Give them a call now. Josh?
How has technology changed the way that you mediate? And I went to break using the word Zoom, but I mean, even things like PowerPoint and presentations that people use for openings, technology has changed a lot, the mediation process, hasn't it?
Well, it really has. The most important thing that you've just mentioned here is the four-letter word Zoom.
Yeah.
I never heard of Zoom, I think, before the pandemic. And here we are with it being necessary for each mediator and all the parties to learn how to function in Zoom. It's been great for the very reason that you've mentioned, Josh, at the outset, which is with this pandemic, all of a sudden cases are not moving anywhere because you can't bring juries to the courthouse, the lawyers can't be there, and we all have been forced to stay at home. But with Zoom, we now have the vehicle for cases to continue to move, for people to be safe and still get the opportunity to have their day in court. So we started out, at least I started out in my career, seeing a lot of PowerPoint presentations or videos, presentations by the lawyers. Those sort of went away. And now there's much more of a focus on being focused in the mediation itself so as to minimize things that might disturb parties, get them unreasonably upset, and to concentrate instead on the merits of a case.
What I've always wondered this of a mediator, what importance do you place on having an insurance agent either through Zoom or in person engaged in the mediation process at the time of the mediation? Because I know the client's going to be there generally with the plaintiff lawyer.
Right.
How important is it to have that person solely engaged in what's going on in that mediation?
Well, it's hugely important. It's possible for lawyers to be given authority by an insurance company or client to speak in an authoritative sense to get a case settled, but there is really nothing like having the person who really and truly has the ability to make a decision about how much money will be allowed in the negotiation process to settle the case. There's nothing like having that person participate directly as opposed to having to call them on the telephone or to speak after the mediation takes place.
Yeah, one of the things I was going to mention, we hadn't really covered it today. I know we're kind of winding down on this final segment, but there's another part of alternative dispute resolution which is called arbitration, which just quickly is a lot of times when you sign a contract, you may be forced to arbitrate with an independent arbitrator as opposed to giving yourself the right to a jury trial. We've gone back and forth about the importance of arbitration, whether it's good for the plaintiff litigator or not. I would argue, our firm holds one of the largest arbitration verdicts in the history of Alabama. Sometimes arbitration can be used in a very positive way. The one thing I would say, David, is this. If arbitration is an issue when you're signing contracts, know what your rights are associated with it. All you got to do is call a guy like me for a free consultation to tell you whether it's good or bad in this circumstance to arbitrate. But arbitration is also something that is a way to resolve claims outside of the jury process that we could do a whole show on.
Right. We've unpacked a lot tonight.
Yeah.
Less than 2 minutes remaining. I want to give both of you the opportunity for a final thought. And Ken, if you would, you go first, please. Sir.
I'll be happy to. Have you ever seen this show where there's a fellow named Caesar who would train dogs, bad acting dogs, and the way that he got both the dog and the dog owner trained was to exhibit leadership. And his whole theory was you've got to be the pack leader. So this point that Josh has been emphasizing truly is important, and it's important for the mediator in a calm way to sort of be the alpha dog for bad acting actors. Yeah. And if the mediator can successfully adopt that posture, so to speak, then we have a chance to get it all done. Our goal is to do no harm.
Yeah. Josh? Clients can recommend mediators no different than lawyers can. If you're watching the show today, I will just tell you this. Recommend to your lawyer that Ken Simon mediate some cases for you because he's really good. Leadership, calmness, super important. If you want to know how important the mediation process is, David, I'm mediating 4 cases in the next 6 business days. So mediation is everywhere, and it's not going anywhere. It's a great way to potentially resolve cases that don't end up through litigation being tried.
All right. Enjoy the time.
Thank you for being on, Ken. Good to see you.
Thank you for the invitation.
Absolutely.
I appreciate it.
Great job. Really appreciate the time, and thank you for your time as well. We'll look for you next time. See you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.